This call is now being recorded. Even here it's ringing, ma'am. Maybe because of that. Morning, Varna sir. Sir, you're mute.
Service
Good morning. Good morning.
Morning. How are you, sir?
As usual, nice to see you after a long time. It is a privilege for me to you after.
Nice to see you after long back.
Yeah, have a nice time.
Lockdown
Hope,
inside the home.
yes.
Service start, ma'am. Rita, ma'am. Sujata,
Yes,
ma'am.
yes, please start. Please.
A very good morning to one and all present here. And respected today's guest speaker, Dr. Sujata Bhattacharya, ma'am, Principal Nowgong Law College. Respected Smita Brahma, Principal and House of Cooperative Law College. Respected Dr. Pranaguma Judicial, Director IQC Cooperative Law College. And respected all the esteemed colleagues and enthusiastic participants of this session. I, Dr. Surgery, Assistant Professor of KLC, on behalf of the organizing team, welcome each and everyone in this 11th episode of Let Niranjan Kumar Bhattacharya Memorial Online Lecture Series. Now, I would like to request Dr. Pranay Kumar sir to give the welcome address for today's session. Over to you, sir.
Thank you, Smita madam. Good morning, one and all, and welcome to our chief speaker today, Dr. Sujata Bhattacharya. She is the principal of Nagaon Law College, and today we are in the 11th episode of Let Niranjan Nursery online memorial lecture series. For last many days we are trying, and in some way or the other have been successful in organizing this lecture series on a virtual platform. And today amongst us, a very renowned, experienced law teacher under Guwahati University. Presently, she is the principal of Nagaon Law College, has joined us as the chief speaker of the day. Dr. Sujata Bhattacharya has a very strong background in teaching students in different capacities. She has also the experience in dealing with many of the seminars, participation, and as well as presentation. As far as I know her, she is very polite, gentle, and soft spoken. At the same time, he has a very nice administrative capacity. Therefore, it is our pleasure from the IQAC cell of Kokrajhar Law College to welcome you, madam, to speak on a topic, jurisprudence concept of law. Now, madam is possibly the right person to make our students elaborate on the topic, and this is very relevant for the purpose of their examination as well as to enhance their knowledge potential. As you know, in jurisprudence, concepts, different things, theories, etc. are there. Madam will be certainly speaking on that. But besides that, HLA Hart published the book The Concept of Law in the year 1961, which is also very renowned work, primarily criticizing Austinian theory of law. Anyway, he advocated for primary and secondary rules. But today in the class or in her lecture, Madam will speak elaborately on the different facets of the concept of law. And therefore, it is my humble privilege to welcome you, Madam. At the same time, I take the privilege to welcome the chairperson of the IQAC cell and principal of Kokrajhar Law College. I also welcome the faculty members, coordinator, and other faculty members, along with student friends and participants in class. They are very warm Greetings to all of you. Hope today's lecture will enable all of us to immensely to gather some knowledge on the topic and to have some important insight uh, into the subject. Anyway, thank you very much for joining us.
Thank you, sir. Before going to start our technical session, I am taking the privilege to introduce our speaker, Dr. Sujata ma'am, who is going to enlighten us on the topic jurisprudence and concept of law. Dr. Sujata ma'am is presently working as principal of Nowgong Law College. She did her LLM from Guwahati University with in specialization with constitutional law and human rights. She has been awarded PhD from the Department of Law, Guwahati University. Before joining the Nagaon Law College, she started her academic career in the School Law College, Guwahati, as an assistant professor. She is also associated with various organizations like Northeast Diocesan Social Services, SCORE, its Center for Organizational Research and Education, and Indigenous Peoples Center for Policy and Human Rights in India's Northeast, etc. Previously, he has also engaged in litigation under Guwahati High Court. So we are honored by your presence in today's session, ma'am. Once again, I extend my warm welcome to you, ma'am. Another platform is all yours, ma'am.
Thank you so
Over to
much.
you.
Thank you, Suhita. Thank you, Pranay sir. It's really been, I feel really privileged to be with you, and I offer my sincere thankfulness to Prita madam for giving me the opportunity to meet you on this virtual platform. What has been said about me, it's not like it's the because of you all are humble and very humbly introduced me, but I'm a student of law. I'm trying to understand what is law and what is jurisprudence, and it is like, I would rather say it's the audacity to speak in front of you, like Aditya sir, Prita ma'am, Duhita ma'am, and all the bright faculties of Kokrajhar Law College. I try to do justice to the subject. Actually, I have prepared the topic from the point of view of the students. As we are under the Guwahati University curriculum, it is the part of the our syllabus, and it is the third semester, BLLB third semester paper, and BLLB I think seventh semester, and LLB third semester paper. So the jurisprudence subject comes to us as a very tough subject and not very interesting subject to us. Like we have other papers in our syllabus like IPC, CRPC, evidence, contract, tort, then environmental law. In all this subject, what we study certain provisions of law. And we get the knowledge of applying those provisions in a suitable case. But the concept of jurisprudence, the subject jurisprudence, it doesn't talk about any provisions of law, but rather this subject gives us the understanding of what law is and how law operates in the society, how law shaped the society and society shaped the law, and what are the other concepts underlying the very meaning of the law. So the jurisprudence subject, the term jurisprudence, used in different contexts. If we see the meaning of the jurisprudence, it is nothing but the study and theory of law. And the scholars of jurisprudence, we all know those scholars, we term them as jurists or legal theorists. And their hope is to obtain a deeper understanding of the nature of law, of legal reasoning, of a legal system, or of a legal institutions. If we go to the etymological meaning, etymologically, the jurisprudence derived from two Latin words. One is jus, another is prudentia. If we see the meaning of the jus, it is the law, and prudentia is the wisdom or skill. So jurisprudent is the one who is wise or skilled in law. But in English uses, we are not using this meaning. That means the meaning given under the etymological meaning, the law and wisdom or skill of law. It is not used in English uses. Rather, English uses of the meaning of the jurisprudence interchangeably used to refer philosophy of law and legal theory. Two terms, philosophy of law and legal theory. And sometimes it appear in a sense equivalent to the French expression la jurisprudence, which means the case law or that part of positive law or actual law which is built upon judicial decisions rather than enacted law or codified law or statute law. Someone is showing the slides, right? We come to the next. Can you come to the next slide? Anyone hear me?
Yes, become
Yeah, ma'am. You can see, right? The third slide.
Yes. I'm yeah. Okay. Actually, I'm because of network problem. I'm using phone. It's very difficult. Okay. So, philosophy of law, which is also called the jurisprudence. It is a branch of philosophy that investigates the nature of law, especially in relation to human values, human attitude, human practice, and political communities. So traditionally, philosophy of law proceeds by articulating and defending different propositions about the law. And it must be general and abstract. See, we have used two terms, general and abstract. So the philosophy of law or the jurisprudence must be general and abstract. Why? Because jurisprudence or philosophy of law not only true to a specific legal system at a particular time, but also to all legal system in the present and perhaps of all laws at all time. That's why the philosophy of law is general and abstract. Now there are different meanings, different aspects of jurisprudence, and we have used the term jurisprudence with different meaning. But there are most common four aspects are there. Most commonly we use by the word jurisprudence. The first one is jurisprudence seeks to analyze, explain, classify, and criticize entire bodies of law. And where we will find? We will find all this in law textbook, legal encyclopedias, and it's represented by different scholars. Then the second type of jurisprudence, the second aspect of jurisprudence, it compares and contrasts law with the other field of knowledge like literature, economics, religion, social science, political science. So the second type of jurisprudence, it compares and contrasts the law with the other field. The third type of jurisprudence, it seeks to reveal the historical, moral, and cultural basis. Historical, moral, and cultural basis of a particular legal concept. For example, like property. What is the historical concept of property? What is the moral concept of property? What is the cultural concept of property? How it developed, how it evolved, and what the concept property talks about in today's context. The fourth aspect, jurisprudence always focuses on finding the answer of the abstract question, what law? What is law? And second most important aspect, how do judges properly decide a case? Like there are different types of law, lots of legal provisions in front of us today, thousands of legal provisions. It is the task of the lawyer, it is the task of the judge to pick the appropriate one and to apply the one. It is the study of jurisprudence that gives us the knowledge how to pick the appropriate one and how to apply the appropriate one and how to satisfy the needs of the people according to the facts, according to the case before it. So it is very difficult to have a common definition of the term jurisprudence, even though the different jurists time to time has tried to define jurisprudence. We will study some of the definitions, not all, because it is very difficult. It is a vast subject. If in fact the definitions, if you have to study the definitions of jurisprudence, it will take more than a day to discuss about it. It takes our entire life to study the definitions of jurisprudence. So we will study some of the definitions. First, the Alpian Roman jurist, he defined jurisprudence is the knowledge of things that is divine and human, the science of just and unjust. So by studying the jurisprudence, it is we will understand what is divine, what is human, what is just and what is unjust. So jurisprudence refers to that study. Then Austin says it is the philosophy of positive law. He is an English jurist. He is also known as positivist. He says that jurisprudence only confined with the study of positive law. And he also says that there are two kinds of jurisprudence. One is general jurisprudence, another is particular jurisprudence. And he says that general jurisprudence is the philosophy of positive law, and the particular jurisprudence is the study of the that particular positive law actually obtained in a specifically determined nation or specifically determined legal system. So he confined his study of jurisprudence only to the positive law. His definition has been criticized by many jurists, specifically Salman and Holland. They says that the classification given by the Austin is not proper, not appropriate. Holland, he defined jurisprudence as the formal science of positive law. He also confined his study to the positive law, the law as it is, that means existing law. But he says that it is a formal science. His definition is again criticized on the concept of formal, because he himself is not defined what is formal. Then Salman, his definition is widely accepted. He says that it is the science of the first principle of civil law. He followed the Austin definition, but goes little bit extent to the definition. He says that it is the principle of the science of the first principle of civil law. Again, he says that it may be generic, it may be specific. So generic define the science of the jurisprudence as the science of civil law, and specific that in the sense that it defines the first principle of civil law. He agrees both Austin and Holland to the extent that it is a science. It is a systematic study of basic principles of legal system. But he also confined his definition to the study of positive law. Then other jurists like Kitten, Allen, Patton, those are some jurists. They also try to define the jurisprudence. They said that it is the systematic arrangement of general principles of law. It is the systematic scientific synthesis of the essential principles of law. Then in the last part of 19th century, or we can say the first part of 20th century, some socialistic point of view been given to the concept of jurisprudence. Roscoe Pound says that it is the science of law, and by using the term law, he says that it denotes the body of principles recognized and enforced by public and regular tribunals in the administration of justice. So he used another term, administration of justice. So if you see the definitions, and in the modern context, it says about the definitions as the scientific or systematic study of law, and it may be particular to a particular legal system, applicable to a particular legal system, and it may be general, that applicable to all the legal system at all the time. So jurisprudence, we cannot confine jurisprudence to the study of only civil law or the positive law. We have to the jurisprudence must have to give us the insight on the various other extrinsic factors that influence the law. So it is clear from the above definition that there is no commonly agreed definition of jurisprudence. Not a single definition can satisfy the needs of the term jurisprudence. And there are other emerging subjects nowadays like medical jurisprudence, engineering jurisprudence. So it is very difficult to have a clear and concise definition of the term jurisprudence. Now, why we need to study jurisprudence? Kyo lage? Kyo pohibo lage jurisprudence? Jurisprudence, the first need is that the subject has its own intrinsic interest and value, because this is a subject of serious scholarship and research. And this research in jurisprudence contribute to the development of the society by having the repercussion on the whole legal, political and social control of thoughts. Legal, political and social control of thoughts. So one of the tasks of this subject is to construct and elucidate concept serving to render the complexities of the law more manageable and more rational. It is the belief of this subject that the theory can help to improve the practice. That's why we need to study the law. Jurisprudence also have an educational value. How? It helps in the logical analysis of the legal concepts, and it sharpens the logical techniques of the lawyer. The study of jurisprudence helps to combat the lawyer's occupational view of formalism, which leads to excessive concentration of legal rules for their own sake and disregard of the social functions of the law. They have to concentrate what is given in the law book, right? And at the same time, they also have to see the social factors. So it is this jurisprudence that gives the insight, gives the value, gives the knowledge. Okay, so that they can confine themselves within the prescribed limit, and also they have to give the take the stones, the building stones from the other societal factors. Next, the study of jurisprudence helps us to put law in a proper context by considering the needs of the society and by taking note of the advances in related and relevant disciplines. So related and relevant disciplines, the economics. If economics develop, then we need to develop the law also. If the political science gives us a different theories, then we in the same context we have to give the definition of the law also. Okay. So the study of jurisprudence helps out to put in the proper context, considering the needs of these other relevant and related disciplines. Next, jurisprudence teaches us to look forward and to realize the happenings around us and to find out the answers to a new legal problem which is not covered by the existing law. That's why sometimes, not sometimes, in fact, in every time, jurisprudence is referred as the eye of law or the grammar of the law, because it throws light on the basic ideas and fundamental principles of law. By this jurisprudence only, we can understand the nature of the law, its concept, and distinctions between the different concepts. And we can find out the rule of law, actual rule of law. It helps us in knowing the language, grammar, the basis of treatment and assumptions upon which the subject, the basic concept of the subject rests. Therefore, some logical training is necessary for a lawyer, which he can find from the study of jurisprudence. Okay, so while applying a particular principles of law to a particular case, we need the logic, we need the logical training, and it is the jurisprudence train the mind of the lawyer logically so that they can appropriately use the principles of law to the appropriate case. Next, it trains the critical faculties of the mind so that they can dictate their fallacies and use accurate legal terminology and expression. It helps the lawyer in practical work. Okay, so lawyers every time has to tackle the new problem every day, and every problem is unique to them, every problem is new to them. This, it is the lawyer, he has to handle through his knowledge every case. So it is the jurisprudence that gives him or trains his mind to handle this new principles, new problem, and to apply this principle to the fit case. Then jurisprudence and helps the judges and lawyers in ascertaining the true meaning of the law passed by the legislator. While passing the legislators, the law passing the legislators pass the law, they have a particular mind, aims and objectives of the law. It is the jurisprudence, that gives the knowledge to the judges and the lawyers to understand the true meaning of the passing of the law. Because the judges, they're not sitting in the parliament. Lawyers, they're not sitting in the parliament to enact a particular law. But they also have to find out why the law has been passed out without sitting in that platform, isn't it? So the jurisprudence gives them that knowledge, that values through which they can identify, they can get the knowledge why the legislator has passed the law. And that's how they can ascertain the true meaning of the law passed by the legislators. Jurisprudence gives us the opportunity, gives the opportunity to the lawyers to bring theory and life into focus in relation to the human social coexistence. It is the jurisprudence that trains the human mind, that trains the lawyer's mind, and gives the opportunity for the lawyer to bring the theory and life into focus, for it concerns human thought in relation to social existence. So that's these are the services given by the jurisprudence. That's why we need to study jurisprudence. And the main task of jurisprudence is to give the definition and understanding what law is. What is the concept of law? What are the different aspect of the law? Different questions come to our mind while talking about law. Why we need to follow law? Why morality should be there? Why positive law is not always not always abide by the citizens? What is the moral obligations of the citizen to follow a law? All these questions answers will get in the different dimension of jurisprudence. Let's come to the concept of the law in the perspective of jurisprudence. What is law? What is law? In the present context, যেতিয়া law বুলি কম তেতিয়া it comes to our mind, everybody's mind, তোমালোকৰ সবৰে মনত আহিব যে it is the mechanism of social control. Law is the mechanism of social control. So we can possibly define or describe law as the body of official rules. Keep in mind, official rules and regulations generally found in generally found in constitutions, legislations, judicial opinions and like, and is used to govern a society and to control the behaviors of its member. Okay, so we can define law as a set of rules that societies have to follow in order to maintain the social order. So law shapes the society. How? It impacts on every human activity undertaken within the society. From birth to death, law impacts on our every daily activities. Other way around, we can say law is shaped by the society, because we cannot perform law in vacuum. No, we have to perform law in where? We have to perform law in the society. So society performs the law based on cultural background, and law is a part of the cultural society, cultural structure of a society. So law is shaped by the society. Duitai শুদ্ধ. Law shapes the society and law shaped by the society. So we can come to the end that law is a part of the structure of the society. Law both shapes and is shaped by the society. Now come to the definition of the law. What is law? So we can have three types of definition. One is lexical definition, another is stipulative definition, and the other one is theoretical definition. Now what is lexical definition? Lexical definition means, by this definition is given in the sense in which the term law is understood in a language community. How a particular society understand the concept of law. This is given by the lexical, under the lexical definition. Stipulative definition kot paba, where we will find this definition in the law book, statute book. Okay, stipulative definitions are very common in legislations and reports, and it is given in the sense law is stipulated in a particular legal text. Okay, this definition is more clear and certain. You have already come across lots of enactment, lots of statutes, so you will find the definitions of clauses there. So every term used under that particular law has been defined. So it's have a clear and certain definition. This is the stipulative definition of law. Another one is the theoretical definition. Theoretical definition is based on the history of the development of the law. It's based on the scientific assumptions. Okay, is the theory that describe what law is from the point of view of the development, evolution of the law. Okay, so likewise the jurisprudence, we also don't have a commonly agreed definition of law, but we use in broader sense the theoretical definition of law, which gives us the better understanding of fundamental aspects of law. This, to define what law is fundamentally is a philosophical inquiry, and it is the main task of the jurisprudence. Okay, so jurisprudence refers to the body of the substantive legal rules, doctrines and interpretations and explanations that make up the law of a country. Second meaning of jurisprudence, it refers to the interpretation of the law given by the court. Third meaning of the jurisprudence, it consists of scientific and philosophical investigation of the phenomenon of the law and justice. Okay, so while giving the definition, lexical, stipulative and theoretical definition, the jurisprudence has these three tasks, and it talks about these three aspects. First, it talks about refer to the substantive legal rules, doctrines and interpretations and explanations that make up the law of a particular country. Second, it refers to the interpretation of the law given by the court. Okay, so stated law given in the statute book, for example, like Article 21, what is written in the Constitution and what is interpreted by the judiciary, by the court from 1945 to 2021. Okay, third meaning, it consists of the scientific and philosophical investigation of the phenomenon of law and justice. Two concepts, law and justice. Okay, law, by applying law, we need the machinery needs to achieve the justice. So this is the subject matter of the study of the jurisprudence. Okay, now come to the different definitions given by the several jurists regarding the definition of law. Here you can, I have given some definitions like Plato, Aristotle, Karl Marx, Max Weber, John Austin, H.L.A. Hart. Okay, so it is the contribution of the jurisprudence to a deeper understanding of law by reflecting on the ideas that define the nature of law and on the assumptions that underlie the legal practices and institutions. So what are the definitions given? If we go by the words, like what Plato says, an embodiment of reason. What Aristotle says, the law is order and good law is a good order. Law is order, good law is a good order. Okay. Then the Thomas Hobbes says, it is the glue that holds the disorganized society. That means it is the glue that hold the disorganized. কি কৈছে এইটো actually যেতিয়া society এটা birth হয়, when the society the very inception of the society, the members of the societies are not organized. It is the task of the law to make them organized, to keep them in proper places. It is the task of the law. It is the law that holds the disorganized society in an organized manner. So there are several definitions I have given in the slides. But it is the task of the jurisprudence. It is the one way of the jurisprudence to contribute the deeper understanding of the law. So what is the first way of jurisprudence? It gives the deeper understanding of the concept of the law, reflecting on the ideas that define the nature of the law. The second way is the giving the tools, the techniques that we use, that the lawyers or the judges used in evaluation and criticism of the existing law. Okay, all the time the existing law is not actually satisfying our need, so we need to criticize that law. So jurisprudence gives us those tools, those techniques through which we criticize the law, existing law, and make it more usable, make it more functional, make it more proper to the present context. Okay, so the questions focuses on this evaluations in the criticism, why we should obey law, whether a citizen have a moral duty to obey the law, what is the right balance between the individual and the collective interest. These are the these are the points focused on by the jurisprudence and tries to give the precise definition of the law. So while giving the definitions of the law, the jurisprudence operates in 3 dimensions. First one is general analytical jurisprudence. Second one is particular analytical jurisprudence, and third one is normative jurisprudence. So the definitions given by the general analytical jurisprudence, it talks about the general concept of the law. It gives the meaning of the law in general and the major concept. Particular, it focuses on the particular concept. Okay, it it focuses on the certain basic concept of the law, which is almost common to every legal system. Maybe some exceptions are there, but it's almost common to every legal system. So general analytical jurisprudence, it focuses on the concept of law. It tries to find out the universal valid definition of law. It distinguishes law from the other types of norms and social practices, and it talks about the general theory of law in all cultures and times. Then particular analytical dimension of jurisprudence, it focused on the basic concept of law which is most common to almost all the legal system of the world. And it tries to observe the commonalities of legal system. And that's how it tries to establish a theory of legal system. The normative dimension of jurisprudence, it tries to focuses on the questions like why we need to obey law. Does a citizen have a moral duty to always obey the law? What is the right balance between the individual and collective interest? What is the relation between law and morality? What is the difference between legal rights and legal duties? Okay, all these answers we will get in the normative dimension of jurisprudence. And that's how the definitions been given under the of the concept of law given under the jurisprudence. Then, like, we will go to the next, like the civil law and the common law afterwards. Before that, come to the next slide.
Is this okay, ma'am?
Yeah. Common law and civil law. Afterwards, we will do this one. And so, by this three dimensions, what we get today, law is an artificial mechanism designed to channel human behavior into the directions the society wants. Okay? In this aspect, law consists of three elements. Number one, words and the other signs and symbols that contain in the language of law. That means the law itself. The words, the words used in the law. Like, no one should be deprived of his life and personal liberty except procedure established by the law. These are the words used in Article 21. The first element of law, it is the words and the signs and symbols that contain in the language of law. The second element of law is the setup of authorities, authoritative interpreters and appliers of the law. That means the judges and the courts. Okay, so these are the second element. The second element talks about the authoritative. That means you need to you need to have the power to interpret the law. Third setup, that enforces the law. That means the police or prison system. When the words of the law tell us to do something or refrain from doing something, we react to those words. Okay, and law uses in ordinary language and ordinary words have a very signaling power to the human.
One second, ma'am, you are muted. Ma'am, kindly unmute yourself.
Okay?
Yeah.
Sorry. Wait. In which slide we were? We were in the... Okay, so we are in the three. Law as a mechanism consists of three elements, right? The first, the words and the other signs and symbols that contain the language of the law. Second, the setup of authoritative interpreters and the appliers of the law. Third, setup of enforcers of the law. That means the prison and the police system. Okay. So, what is the law? Law is the channel of our behavior in a social group. That means law channels our behavior in a social group in many ways, other than a simple one of telling us to do or refrain us to doing from something. That means legal rule can be presented like this, like what must I do or avoid doing. That means law tells us to what to do, what not to do. So in that context, law has three different forms. One is prohibition, another one is prescription, and the other one is the powers. What is prohibition? Law channels our behavior, telling us to refrain from doing certain things. When the words of the law tells us to do something or refrain from doing something, these words signals to us that unless we do that, what described in the legal rule, certain unpleasant consequences will happen to us. That means it prohibits law, gives us certain prohibitions. That means certain boundaries within which we have to perform, we have to behave. Second, prescriptions. Prescriptions means law requires us to act in certain way. For example, law doctor prescription diya jana hai. So how to behave, like the how to pay the taxes. It is a prescription. Then second one is conditional statement. Third one, last one, that means powers. Conditional statement. These are the rules of law that comes to us in the form of conditional law that empower us to do certain things. That means after my death, I want to give my property to somebody else. Okay, so I may or may not, but law empowers me to to assign someone else after my death. Okay, so if I want to succeed in transferring my property after my death, then I can execute a bill. So it is a kind of powers given by the law. Okay, so this is the definitions of law must give all this 6 aspects. First, it must give us certain words or signs and symbols that contains in the language of the law. Second, it must give the authoritative interpreters and the appliers of the law. Third, it is a setup. Law is a setup of. It must give a setup of enforcers of the law. Okay. Then, while channeling of our behavior, law must come in 3 different forms. One as prohibitions, second as prescriptions, third as powers. Okay. Now come to the different types of law. I'm talking about the types of law not to a particular legal system, but in general, and it is the study of the jurisprudence, general jurisprudence, like what are the different types of law. So historically, in today's context, almost all the major legal traditions will follow two types of legal traditions. One is common law, another one is civil law. Common law. What is common law? Common law is the law developed in the uncodified law. It's the emerged in England beginning in the Middle Ages and based on the case law or the precedent rather than codified law. Okay. And civil law is the law that emerged in the continental Europe in the Middle Ages and is based on the codified law drawn from the national legislations. So most legal system in today's world, we use this two types of tradition. One is the civil law, another one is common law. So if we make different types of law, then we will find 2 types of law. broadly broadly speaking. One is private law and another is public law. Private law that governs the relationship between individuals, such as citizens to companies. Public law that governs the relationship between the individuals and the state. Okay. So private law may be civil law, labor law, commercial law. These are maybe private law. What is civil law? Civil law is a body of rules that determine the private rights and remedies and governs the dispute between the individual in the cases of contract, property, tort, and family relations. Labor law, employer and employee relationship. This area, private law, includes individual employment contract, contract doctrines, and a large group of statutory instruments or issues as a right or organized to negotiate the collective agreements, protection from the discrimination, and health and safety of the worker. Then the commercial law. Commercial law, it governs the business transaction in domestic and foreign trades. Okay, transactions between business entities. This area, private law, includes all aspects of business, including advertising and marketing and trade in general. These are the private law. Public law, we all know public law, constitutional law, administrative law, and the criminal law. Constitutional law means what? Constitutional law, that the body of rules that governs the relationship between the state and the individual or between different branches of the state. Administrative law, body of rules that govern the bureaucratic procedures, okay, and defines the powers of administrative and governmental agencies. The last one is criminal law, that the body of rules that defines the conduct prohibited by the government because it harms the public safety and social welfare. The state establishes punishment to be imposed for the commission of such offenses. Okay, so these are the public laws. This, in nutshell, we can say this is the concept of law in the jurisprudential perspective. And the scholars of jurisprudence, the legal theorists of jurisprudence, continuously tries to define the law and continuously trying to giving a definition that satisfies the needs of all the people in all the time. So this much from my presentation regarding the concept of jurisprudence and the concept of law.
Thank you, ma'am. So, participants, if you have any queries, then you can directly interact with ma'am.
Yes,
I think there is one question in the chat box. By Mantu Sarkar. Yes, ma'am.
Wonderful presentation.
I don't know, but I am trying to give very simple words to the students. It's very difficult to define jurisprudence, very difficult to define the concept of law. And I'm really very scared, really very tense to speak in front of Aditya sir, in front of you. I don't know whether.
Oh, thank you. Excellent presentation, excellent work you did. So it is really beneficial for all of us. Thank you very much.
Concrete words that being used by you for easy understanding. So I think there are some one or two queries in the chat box. Lupita,
Yes.
queries.
One of the students, Mantu Sarkar, he wants to know the law govern the international states like European law. But what are
the law govern the international states like Europe and European Union. Those are what type? Okay, if we see the jurisprudential context, so law must have certain characteristics. Okay, and if those characteristics not been fulfilled, then under the jurisprudence we cannot call them as a law. So what you ask me, law govern the international states. Okay, law govern the international states means international law is not the proper law as it is, as given by the positivist, because there is no sanction. in the international law. Sometimes even Austin described international law as the vanishing point of the law. So actually, the question is not clear, madam. The law to govern the international states like European Union, those are of what type? I think he is talking about the international law. Law govern the relationship between two different countries, like two different
Yes.
states. Okay.
Yes.
Yeah, I think he's talking about international conventions.
International law, yeah, international conventions. So see, the law is developing, and it is the purpose of jurisprudence to study the different aspect of the law. So regulating the behavior between two different countries, also the aspect of the law. It is also the law, but in true sense, what we study, what the jurisprudence study is the application of law to a particular legal system. International legal system is different. That we have even United Nations that regulate that body is not actually regulating body, but this body has given certain principles that the country should follow this principle so that there is peace and tranquility in the entire world. Okay, so that law is not the subject matter of the jurisprudence. Okay,
Yes, ma'am.
I think Mantosh Sharkar.
Mantu sir, are you there? If you want to interact with ma'am.
Okay? Yes. Okay, madam, I got it. Okay, Montes, thank you. Any more
I
query?
think there is no more questions in the chat box.
The subject is like that, Duhita.
Yeah, ma'am.
Subject is like that. It's very difficult to
Yes.
raise query also. Even it's not in the part of the students. Even we also cannot raise the queries until and unless
Yes.
we have a proper understanding. It's very difficult to understand. The more you study, more your concept is been developed.
Yes, ma'am. So thank you, ma'am. Thank you, ma'am, for enlightening us and also sharing your valuable thoughts and experience pertaining to the topic. I hope it will be very fruitful to all of us. And thank you so much for joining us. So now we are at the end of our session. Before concluding our session, we had a formal vote of thanks. So now I would like to request our principal, Madam Ms. Pita Burma, to offer the vote of thanks for today's session. Over to you, Pita ma'am.
Okay, I think Deepavali wants to interact. She has raised her hand.
Okay,
Yes.
okay.
We go for vote of thanks. If you would like to interact, then please unmute yourself.
Good afternoon, ma'am. Yeah, ma'am, I wanted to know, like, as you told, like, there is some interest. I think line is not clear. Hello.
Yes.
Yeah.
I can understand. Yeah.
Yeah, as you told that, as the Austin told that the law is the command, right? So in other side, the Bentham said that it's the will of the sovereign. So I wanted to know from your viewpoint, ma'am, like in based on the natural law, we say that it's a supreme law. The natural justice should not be denied, as according to the Article 21. So it's a quite in fact like there's a confusion with this three concepts. Can you please clear it to me, ma'am?
Yes. So while giving the definitions, I have said 3 points: the lexical, stipulative, and the theoretical, isn't it?
Yes,
So
ma'am.
natural law says that law is divine. That means natural law. At that time, they said that it is the God. Actually, the
Yeah.
custom. It is the
Yes.
God who made the law. That means by this concept, today we find what is equality. God sees everyone equal, isn't
Yeah.
it? So
Yes, ma'am.
equality concept, it not comes from the command of sovereign. Okay.
Okay.
So equality concept comes from the command of God. Rather, we can say it's from the God. So God sees everyone is equal. It's not like that. You all people are good. I will give rain on you. Okay, so that you can raise crops. You people are not good, bad, sinner. So I will not give rain on you.
Okay.
It's not like that, isn't it? So
Yes,
natural
ma'am.
law concept is like that. Then the Austin says it must be the command of sovereign, because they
Yeah.
said the political superior has the power to ruin the political inferior. Okay, so they said that according to the positivist, their subject matter is law as it is. That means the existing law. So when the king says "Roja is ikobo, hitu manibo laibo," what the king
Oh.
says, you must follow. Okay. If you're not following, then you will be punished.
But
So there is no concept of morality in the Austin's viewpoint. But today we are taking the abstract of all these thoughts, natural law thoughts, positive law thoughts, sociological thoughts, and now we are getting the very, fine, flawless law, that the minimum content of morality also there, equality must be there. Okay, so in making the equality, we also has given certain reservation আছে না নাই? Article 49. Okay,
Asim, ma'am.
the reservation is there. So by the reservation, we making some exceptions to the concept of equality. Okay, so the positive law as it is, according to the Austin, is the subject matter of the jurisprudence. But according to the naturalist, like Saint Thomas Aquinas, Thomas Hobbes, they said that it is the subject of the jurisprudence must not only the positive law, but morality. So today what we get is that we must have morality, ethics, everything. So law, the jurisprudence tries to establish the relationship between other sides. We cannot have a legal theory, we cannot have a law without knowing the sociology, without knowing the political science, without knowing the religion, without knowing the ethics. Okay, so everything must come within the purview of law. Then only they can satisfy, law can satisfy our needs.
So basically, it's a mixture of everything.
Yeah, it's a mixture.
Yeah.
It is actually the knowledge.
Okay.
That's why I have said that it is the trigger our mind to think critically. Jurisprudence trigger our mind to think critically, so that we can identify the fallacies of the law.
Okay.
Okay,
Yes,
we can
yeah.
smoothen it up.
Yeah.
ধুনীয়াকে স্মুথ কৰি পেলাই আমি তেনেকে তোমালোকে মেকআপ ইউজ কৰা ন, মুখখন আমাৰ এৰিয়ে থাকে, তাৰপিছত আমি লিপষ্টিক সানিম, কিবা সানিম ন, ৰ'জ পাউডাৰ সানিম, সানি পেলাই কি কৰিম, মুখখন ধুনীয়া কৰিম ন. So same way jurisprudence gives us that knowledge so that we can make the law more appropriate to today's context. Okay,
Yeah. Thank you, ma'am.
thank you, Deepavali.
Yeah.
Yeah, so before we go for vote of thanks, we have Mohan Rao Bolla sir, Harish sir, Nageshwara sir. So would you please
Very good afternoon, my dear friends, and Sujata Bhattacharya ji, namaste, and
Namaste.
it's a very great articulation we could hear, and your reflections on as to how law ought to be as a social phenomenon is very well appreciably delineated, and that's it from me. Very good.
Thank you, sir. Thank you, sir. Thank you so much.
like to inform you, ma'am, Sujata ma'am,
Yes.
Mohan Rao sir, he's a professor of law, and at present he's the principal at Christu Jayanti College of Law, one of the dynamic law colleges.
Yes, I heard about that. Thank you. Nice meeting you, sir. Nice meeting you. Thank
Very,
you so
very
much
nice
for
talking to you.
words
And,
of appreciation.
I can't show myself now, and what I appreciate is that your way of articulating things in such a way and in a pleasing manner with
Thank you so much, sir. Thank you. Thank
that
you.
lovely face you are explaining things. And had there been a possibility to try to explain the heartfuller debate, suppose say Deepavali Brahma was asking about the intricacies of as to what law ought to be and what law is.
Yes.
That there was that debate between Professor H.L.A. Hart and
Yes.
Professor Fuller,
Fuller.
and that would definitely, that will be supplementing to whatever that kind of
Deepavali Brahma wants to know. Yes.
that kind of doubts can as well be very much cleared, and they will have such an idea, and if possible try to delineate that even at a different point of time when you are dealing
Yes.
with
Lon Fuller and H.L.A. Hart thesis. Yes, sir.
Yes, and that debate would definitely answer in a better way, and Deepavali also will have so much of
Yes. Very
insights.
nice queries raised by Dipavali Brahma actually.
That's good. That's good. That's good.
Thank you, sir. Thank you, ma'am.
Yeah, Deepavali, and your issue or your doubt can as well be cleared, and you can even look into this uh, heartfuller debate.
Debate, yes.
Yeah,
Sure, sure, sure.
madam may not be now finding time to explain that, and sometime later also
Let
we
us,
can have that.
yes, that will be a very nice debate, very nice
Yeah,
session.
that kind of debate would refine the law and make the society so well appreciably having such law which would definitely have that philosophical bent of mind, and all the social perspectives also will be reflected into. And
Yes,
basically, morality, that which is opposing morality, or suppose say during that Nazi movement, the Hitler's rules were such that even a mere criticism would make people get killed, and that kind of society. And at that time itself, when there were cases decided by the courts, there was this debate conducted, and two professors, eminent professors, they floated articles which were both were published, and there was that controversy or the debate that led to the generations or the world by and large to know that law ought to be associated with morals, and it shall not in any way be violating such things, and even a dictator is also amenable to morality and law. That's how things have been, and that's what had paved the way for betterment, refinement day by day, so that the law will be an instrument of social justice, and that's what could be the cream out of that. And all the time that kind of debates also only are expected to be there always, and a liar typically must have that delineating and inspiring mind to question every such thing, and you question your questioning or the questions also in law. Thereby there can be the cream out of that, and definitely there ought to be no such law which would be an antithesis to your values and value oriented.
yes.
That's what I feel. And, Harish sir is there now, and we request Harish sir to delineate or
Let's
supplement
light
his
on this
views.
topic. Like,
Sir, good morning. Well, thank you, Professor Bolas. Thank you, Sujata.
and here.
Harish sir, you are not audible. The voice
Your voice is staggering, sir.
uh,
I think there is some streaming problem.
yeah, some problem.
Anyway, sir will rejoin. In the meanwhile, if there are some questions, you might continue the issue, and Madam may be giving such answers, and Harish sir also will supplement.
Okay. Harish sir, I think he's there in the meeting, but we are not able to hear him.
Yes, they're able to hear him. Yes, Mohan sir, actually, this minimum content of morality.
Yeah.
This
Okay.
is very important.
Yeah. See. Okay. I was just trying to say that I think students should understand and the jurisprudence of understanding judicial legislation. Okay. See how, with reference to specific cases like Keshwanand Bharti case and the Vishaka versus State of Rajasthan case. Happening regularly.
Sir, there was some.
There is some problem in the network, I suppose.
Okay. Yeah. You're able to hear me now? Yeah.
Yes, sir. Yes, sir.
You made a mention about
Kesavananda
Bharati, and you made a mention about Kesavananda Bharati.
Yeah, I was trying to lay emphasis on
Vishaka versus State of Rajasthan.
Yeah, I think Sujata
Later
should
part,
try to
later part we could not hear.
Yeah, I was trying to emphasize on Sujata should try to give more or inputs on understanding understanding jurisprudence and the judicial legislation in India. That is the jurisprudence of understanding judicial legislation in India, with specific reference to Keshwanand Bharti case, Vishaka guidelines, and also try to see what is the way forward when it comes to judicial activism and judicial review. Okay, so that people should understand how the law is when there is no existence of a particular law. Take for example, today you don't have a law on surrogacy in India. So you should they should be able to understand and which is the judicial legislation, the precedent and set forth by the Supreme Court, which becomes the law of the land till Parliament passes a regular law on surrogacy in India. And Professor Bhattacharya told about mentioned about questioning the questions itself. Under Article 51A, the spirit of inquiry is a fundamental duty. I always keep referring to Three Idiots sequence where Amir Khan is called to write something and explain to the class. He writes something on the board without asking what the question is. People are busy searching for the answer. This is what happens with the student class, which I have also seen. And so without knowing the question, how are you searching for an answer? You in that sequence, I keep showing that video clipping to students to tell them, see, nobody asked what the question is. Everybody is busy searching for an answer without knowing the question. And a lot of questions students should try to inquire themselves. It's like a reference to context. Why the age? Now there is a debate in Parliament, a pending bill in Parliament to equal the age of marriageable age of girls and boys. Okay, so this I have been voicing for 20 years back. I had in a model parliament session made students to discuss and tabled a bill on right to equality and equaling the age of marriageable age of boys and girls. Okay, so the question should be, people should ask, why was it first made as 18 and 21? Okay, why was this gap met? What is the scientific reasoning? What is the logical reasoning? What is the legal intent and legislative intent of keeping such a gap? So this is what is questioning the questions. This is what is I'm trying to understand, and how judicial legislation versus the legislative intent and of the legislature in this country works when it comes to new laws being made through the subordinate legislative power which the judiciary enjoys through bringing about judicial activism in this country. So these are things which students should. I would always impress upon the organizers and the teaching faculty to take up things which are yet to become a law. So let us look at the new outlook and vision of the youth of today, because the future of this country lies in the hands of the youth of this country, who have a broader vision than our myopic vision. And also we would like to see what is that they feel about these new laws which are on the anvil to be passed by the legislature. So these are things which I would always impress upon on the faculty and the students to look at these things new. What is that new things are required in this country also? See, when POXO came in, it came in a snapshot time, because as Amir Khan showed about this POXO, about the sexual abuse of children, and Sridevi was made an ambassador to see that to lead a team with Amir Khan to meet the government to see that this is passed. The POXO came in much earlier than the POSH Act, the Prohibition of Sexual Harassment at Workplace Act of Men. That came later on, though there is a judicial legislation in Vishaka guidelines. Parliament delayed that one and passed the POXO Act earlier. See, these are things which today surrogacy is a thing. The adoption issue is going on debate every day because of the COVID victims, children who have become orphans, and a lot of NRIs trying to adopt these children. And the CARA is there, a central adoptive agency is there. How this is working, how this adoption and whether the law of adoption across the various religious spectrum, whether it is foolproof enough in this COVID crisis. These are things I would request people to see that we open platform for students to debate on. Thank you for
Yes.
giving me opportunity to share my views on this.
Yeah. Yes, sir. You're
So
right.
good, so good.
So nice. Yeah. We can
Yeah, as sir was just a moment, sir was rightly pointing it out. Um, Vishakha guidelines, as a matter of fact, say there ought to have been place for law, or there ought to have been that particular problem of security of women at the workplaces dealt with by law, and there was no law. When there was no law, how can the courts come to the rescue of people by and large, especially the vulnerable groups? That, as a matter of fact, Sujata madam might take some other opportunity of taking such issues where there is no law. How can the court come, and in what circumstances and with what initiative the court would come forward to render justice? And such opportunities, in a way, I say that the courts have been opportunistic to usurp the opportunity and lay down the guidelines, and that way it had been like a beacon light, even for the legislature to enact such laws whereby there will be the law acting as an instrument of social justice, and that's what is appreciable, and you know pretty well. Yeah, you know pretty well.
Law is, I agree with Professor Bolla sir, law is an instrument of social justice. I would like to add one more dimension to it. Law is first an instrument of social change, which will render social justice.
Yes, definitely.
And the live-in relationship is the other area where there is no exclusive law for relationship. It's the Domestic Violence Act which is covering. Recently, a judgment of some high court says that we cannot give you protection and for live-in partners. Just 2-3 days back, this is, I forget, it must be Delhi High Court or some other high court. So these are things which the youth of today are more towards this prenuptial agreement, live-in relationship, and all these things. So what is their implication? What is the laws which, whether the present laws are sufficient enough? Whether what is that the youth want? What is the change you can bring about? Laws an instrument of social change is also towards social justice, as it is gender justice, as it is gender parity. These are all things which the youth of today and students of law should try to dwell upon, so that their outlook towards the society to bring about social change and ensure social justice is well rendered in the corridors of the legislature of this country.
These issues can be a matter of discussions with the youth, with the students actually, and this should be incorporated in our lectures. These are the emerging topics, and when there is no law, how we will proceed? What is the result before the court, before the lawyers to dwell upon those cases where there is no law?
Yeah. The other thing is, when drafts are being published in the Gazette of India and also by select committees of the Parliament, they are published in the Gazette. None of the law students till today, I have been regularly giving suggestions and raising objections on all these bills in the draft stage. None of the student community come forward to voice their opinion in this. Okay, this is what we want: proactivism at the students of law. Take up issues which are pending. Click on to the website of Lok Sabha, pending bills. You will know how many pending bills are before select committee, how many are before the joint parliamentary committee. Try to give opinion, give suggestions to this. Lead a delegation of college students to go and meet this committee. We can get public hearing will be allowed by these committees. I have been there in so many of these things, including a prevention of corruption bill which had come referred by Delhi FICCI to us. I told them to add 2 more dimensions to the definition of corruption, bribe. I said bribe giver and bribe taker. I gave two definitions. I told them it can be added. One is coercive bribe giver and collusive bribe giver. Collusive bribe giver is he strikes a deal before the tender is passed. I says, I'll give you a cut of this much percentage. That's a collusive bribe giver. You punish him. Coercive bribe giver may be a lady in the hospital who is delivering a baby. Baby will not be shown to the lady if money is not given to the nurse. Coercive bribe giver. She is forced to give bribe. Otherwise, the child is not shown. Don't punish such people. See, this is what we are looking at. New dimensions, new vistas as of new vision by the youth of this country. I don't see anybody, everybody starts fighting, protesting on the streets after the act is made. With
Yes.
the draft stage,
Before the act, yes.
objections should happen because there is time given when in the Gazette, because I am regularly interacting with all these legislative research things and other things, so I am aware of every Gazette notification I get. I am aware of what laws are pending, how many bills are pending, and what is before the select committee, what is before the parliamentary committee. Do it in your own states for your own state laws first before you go to the parliament also. I would suggest this to happen.
Very nice, sir.
I am ready to partner with any institution and give them guidance on all these matters because I am aware of all the gamuts of law which are pending before the parliament and various legislatures. Now the latest one is the legislature has circulated some drafts to all the states. It's okay. So like that, when the states let's get some draft, people in the local area should also raise their voice.
So good, sir. It's a very good suggestion, and generally thereby there can be people's participation in even making the law.
Yeah, we want participatory democracy.
Yes,
I want participatory democracy.
That's what can be visualized, and there can be that kind of society which can be named as a learned society or learning society. And surely that should be, and the syllabi also must have space for such things. And now I think Preeta is very much worried about completion of the syllabi.
Yeah.
There were all these topics syllabus oriented.
Syllabus oriented, yes, sir.
Yeah.
Syllabus oriented, and it should be incorporated in the syllabus.
Are being dealt with, and therefore, there ought to be that kind of even examination system, whereby there ought to be that framing of the bills also must be made part of the curriculum, at least at the fag end of the career. Thereby, there will be such inputs, and as Preeta knows very well, in Christ University, we have had at least 18 to 20 clubs. Say, public policy club is one of the such clubs which would take up this assignment which sir was mentioning. Go through the bills that are in making and conduct such symposia or panel discussions and researching into various aspects. Say, we did when I was the convener of that public policy club or committee, whereby we were discussing about the intricacies of death penalty, and we even sent the report to the law commission. Now what we are seeing is that law commission has made almost a dysfunctional institution, and nothing new is happening based on the commission, the recommendations of the law commission. And it also there shall be such mandates whereby the law shall be made in consultation with all such institutions and all the stakeholders. And for namesake, there has been projection of those, or suppose say the placing of the bills in the website, official website, and it's not reaching to the common man all the time. And always it has been a lone voice of some few Harish sirs and they may or may not be taken into consideration at times. Anyway, today I feel that there is a very good academic feast that is shared to all of us by Sujata Bhattacharya ji, and it's well done, a webinar on the concept of law. Thank you very much.
Preeta should consider some of these topics like one nation, one election, whether right to die, whether attempt to suicide should be a punishable offense or not. See, these are all things, whether it is coming in the way of right to die. So many such things.
Correct, that's correct.
Should be able to elicit opinion of the youth of this country. Thank
Yes,
you.
we'll try to incorporate such debatable issues in our lecture series.
And constitute committees in the meanwhile, so that there can be more and more dynamism infused.
See, right to information act came because of not by the government. It came into thing because of the civic society
Yes.
with Kejriwal and others who were leading.
Not only Kejriwal, sir, you were Dr. Mohan here. We were the pioneers who have been working so strenuously for that, and along with Lok Sabta, an organization that was floated by Dr. Jayaprakash Narayan, who is a doctor by profession.
Correct.
But he was the collector and IAS officer. He gave up that post and he started that organization, and
Correct.
we were all striving to get that law, right to information, and that can be a very good tool for bringing in social change as well as to render social justice, as he was pointing it out. Those practical aspects, and as Professor Dwayne puts it, there ought to be that socialization of law, and as Sir was rightly pointing it out, even pre-enactment stage itself, there ought to be such a rigorous exercise to be done, and research-oriented work, and all that kind of discussion, discussing all the intricacies, and that way a cream on a proper law, which would be very good for the people, and the contemporaneous problems are addressed, and thereby there will be law to be a full-fledged instrument of social justice.
This will enable students to understand interpretation of statutes very easily.
Very easy.
That's correct.
Thank you.
That's also an area where we can have a lot of discussion taking place, and a cream would evolve in the form of the best possible interpretations, and competitions also can be conducted in those things. And Harish sir, in the name of Harish sir, you can start one competition, and sir will sponsor the prize. Thank you.
Ready.
Okay, sir. So we have come to an end. It was nice to hear from Mohan Rao sir and Harish sir. Your insights and sharing of knowledge is always welcome. So going to the last agenda of the session, we have.
I share information for the students to process it into knowledge.
Yeah. Yeah, so we have come to an end. So it gives me a privilege to offer my vote of thanks to today's guest speaker, Dr. Sujata Bhattacharya, ma'am. So, ma'am, in the initial stage of your lecture, you have started with what the understanding of law is and how we should understand the law by incorporating the definitions given by different jurists, and how the definitions of Austin has been criticized by further jurists. And you have also mentioned in your session that the definition of law can be found in the legislation, it can be found in the constitution or different rules, and law is there so that the society can be shaped, and also further the society shapes the law, and at the same time the sorry, the society shapes the law and the law shapes the society, vice versa. So you have also tried to categorize the definitions of law into lexical, stipulative, uh, and also you have tried to explain the dimensions of jurisprudence by categorizing into three, that is general analytical jurisprudence, particular analytical jurisprudence, and normative jurisprudence. It gives us an immense pleasure to have you amongst us. You have given an insight knowledge on understanding the basic concept of law, because and you also emphasize that it's not uh, easy to understand the law in the span of LLB course. It takes years, and still you or us who are in a little matured stage than the students, it is, even we are still the law students and trying to understand what the law is and how it can be brought into for the better society to exist, so that the people, society and law can coexist parallelly. So thank you so much, madam, for accepting our invitation within a short period of time and giving us your valuable knowledge of yours and sharing with our students. So thank you, ma'am, and I thank Mohan Rao Bolla sir, mm, the guiding hand, and Harish sir, always being a good facilitator to us. And I could see Nageshwara sir also. Yesterday he was our guest speaker. Yeah, even yesterday's session was one of the superb session that I have to say on Consumer Protection Act, deliberated by Nageshwara Rao sir. He is a retired professor of law from Vivekananda College of Law. So we are delighted to have you once again, sir. And I also take the opportunity to thank IQAC cell of Kokrajhar Law College for putting up a good a program during the time of pandemic, and the teachers and teachers of Kokrajhar Law College for always being supportive, and teachers across other institutions, and my dear students and participants across the different parts of Assam and India. So, with these few words, I take the privilege to thank each of you. Thank you so much.
One suggestion to Sujata madam is in her
Yes, sir.
slide I saw that powers, prescription, prohibition, prescription, and powers. Okay, I would suggest put the powers first, second prescription, and then prohibition.
Then private. Okay, sir. Okay, sir.
Then you ask them to prescribe for themselves.
Thank you,
Then
sir.
you prohibit
Yes.
them if they don't use it properly. Thank you.
Good,
Thank
good.
you, sir. Thank you. Thank you. Your
Thank you.
suggestions are welcomed.
Most welcome, sir. Most welcome. Yes, power is the first thing that law gives us.
Thank you, Sujata madam. Thank
Thank you.
you, Dr. Bholla sir. Thank you, Anit sir. Thank you,